Hey everybody, thank you so much for everybody. We'll go ahead and we will start in just a second. We'll let some people get into the conversation. I do want to thank everybody for letting me know I am now broadcasting live. Okay, so we'll go ahead and we'll take care of some housewarming or housekeeping, not housewarming, but housekeeping. Here we go. Okay. Good afternoon, everybody. My name is David Furman. I'm the managing partner here at Altitude Community Law. I hope everybody is doing great and having a wonderful afternoon. It looks beautiful outside. I hope you're able to go and enjoy it. So on your screen, you'll see a PowerPoint presentation in the center of your screen. This should take up most of the screen. There should also be a small box to the bottom right-hand side, that would be like over here, of the screen with your video feed. That has me. I'm sorry you have to look at me, but you know, it is a webinar. On the left side of your menu, please select the question and answer icon and type your questions there, which will be addressed at the end of the webinar. And it's the little button over here that's got a question mark on it. CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report, which will be sent via email within 48 hours following the webinar. These credits are not transferable, of course. However, if you do have problems or you don't get it, go ahead and email us at education@altitude.law, or you can call Grace directly at 303-991-2076. If you have any questions about receiving your CMA certificates, like I said, she can handle it and make sure everything's a go. I think we have just about everybody that's here that wants to be here, so let's go ahead and get started. This is the annual Case Law and Legislative Update. It is supposed to happen at the end of the legislative season, but of course, as we all might know, this is the year that wasn't. And the 2020 legislative season is actually still ongoing. They are still introducing bills, which is absolutely crazy. They are still pushing bills through. They're dealing with things that, for the most part, are COVID-19 related and budget related. So with that in mind, recognizing that the focus of the legislature shifted during the course of the year, we now have a different emphasis on what's happening. Where am I going? Sorry, everybody. I am not a professional webinar giver. Okay, this is an election year. And why do you care? Well, as I mentioned, the legislative season was shortened because of the COVID-19 pandemic. They adjourned in the middle of March. They just got back to business. And given the onslaught of the budgetary shortfalls caused by the COVID-19 pandemic, the legislature, the state of Colorado is broke. It has no money. So anything that was introduced into the legislature this year that had a fiscal note or a fiscal impact was either cut, trimmed, or dismissed. Okay. As you recall last year, we talked about the makeup of the legislature. Or as you may recall last year, we talked about the makeup of the legislature. And right now the House has 65 members. It's got 41 Democrats, 24 Republicans. The Senate has 35 members. It has 19 Democrats, 16 Republicans. And why is this important? Well, it's important because it's an election year, given the fact that the shortened season and budgetary issues, only half of the agenda was completed by the time they had to adjourn. They still had 6 weeks left in the session, and they had planned on dealing with a whole bunch of stuff that they wanted to get done, mostly the HOA industry. All of our bills that impacted the HOA industry were pushed off to the back half of the session. Well, now that the back half of the session didn't happen, they had to come back in and readdress just about everything they were looking at doing for associations. The big bills, the one I think everybody has heard about and everybody was anticipating, is still alive. But as it was originally introduced, it authorized the HOA information resource officer to continue for 5 years. Okay, that makes a lot of sense. The HOA information resource officer was given authority to collect complaints. It was given authority to educate. It is funded, it is self-funded through the registration requirements contained in Section 401 of the Colorado Common Interest Ownership Act. So they went ahead and they were going to reauthorize it because it's sunset this year. However, it also created a dispute resolution enforcement program, which required the division to draft educational materials on dispute resolution, distribute those, create a toll-free number for owners to call in with any dispute that they might have with their HOA. It required receiving and investigating complaints. So it actually gave the HOA Information Resource Officer investigatory powers. It authorized penalties up to $5,000 for perceived violations. And I say perceived because, again, this was just the start of the process. As I mentioned, as it was introduced, because it gave the HOA Information Resource Officer all sorts of new powers and all sorts of new requirements, it contained a $3.4 million fiscal note. Well, as I mentioned, the impact of the COVID-19 pandemic, anything with a fiscal note was either killed or stripped down. So the current version of the bill is limited to renewing the HOA Information Resource Officer. That's it. However, in the hearing for HOA information, for the renewal of this bill, after they stripped everything out of it, everything was stripped out of it regarding their investigatory requirements. Everything was stripped out of it regarding creation of an HOA. Everything was stripped out of it regarding what they could and could not do. After testimony was on that portion, the legislature allowed a friendly amendment to the bill, and they snuck in what was supposed to be another bill entirely. And it was known as the Religious Freedom Bill. And essentially, this bill is geared at a condominium community or a homeowner association, a common interest community, cannot prohibit the display of sincerely held religious, evidence of sincerely held religious beliefs. So what they did with this is you can now not enforce any covenant the association may have that restricts the display of mezuzahs or crosses, crucifixes, anything like that on common area, on common elements. There are size limits. It's 6 by 6 inches. So it is relatively small, but in the grand scheme of things, 6 by 6 is actually kind of big. And you cannot discriminate against it. You cannot enforce any covenant. When this passes, and we do expect this to pass, you cannot enforce any restriction to force an owner to remove a sincerely held religious belief or evidence of a sincerely held religious belief. Okay. The other big bill, HB 20-1333. This was known as the HOA Transparency Bill, which allowed for taping of meetings by owners, use of election monitors at an owner's sole cost and expense, prohibited the use of secret ballots, required notice of an association's failure to reserve at set levels, and a reason why they're choosing not to reserve at set levels, required disclosure of certain documents and fees, meaning you had to make available on your own website, plus the Secretary of State, not the Secretary of State, I'm sorry, the Division of Real Estate's website, and they were required to form their own new website to upload all your documents to, including your declaration, your articles, your bylaws, your rules, regulations, your insurance policies, your meeting minutes, anything like that was required to be uploaded to a special website created by the Department of Regulatory Agencies. And again, given the majority or the major budgetary shortfall and failure or necessity that the legislature pivot to other financial matters, the bill sponsor voluntarily pulled this bill. However, as I mentioned, it's an election year. She has vowed to bring this back next year. This is Representative Brianna Titone out of West Wheat Ridge. She has promised to bring this bill back. She's now going to have yet another year to work on it and figure out how to solicit input from stakeholders. This bill was largely impacted by owners feeling that their associations just didn't communicate enough and didn't provide enough information. Owners feeling the use of secret ballots allowed associations to rig elections. By not allowing taping of meetings, the association was hiding certain things. So this bill was geared at trying to root out all of those sins of an association. In my opinion, it was very overreaching. It was overly broad. It will need to be trimmed back, and it will need to make some sense next year. But this bill was a very expansive bill and put a large number of burdens on an association to comply with. And this, again, is going to be one of those that it's coming back, and it's coming back with full force, as are the dispute resolution processes they wanted to introduce this year but got cut. Those have vowed to be brought back to next year. So we get a 1-year reprieve for these individual pieces, but expect to hear from me again next year on what's going on with those particular pieces. Okay. And we did get a surprise bill this year. This was just introduced on June 1st. It ran through the Senate and was introduced to the House 2 days ago on June 6th. It is now already through most of the committees. I'm waiting for an update to see what they happened this morning. It was in committee hearing. I fully expect this bill to be referred to the full House for a vote today. What this bill does is it limits what they call extraordinary collection activities. And that means essentially realizing on a judgment. Now, while an association can still go get a judgment, meaning if an owner is refusing to, is not paying, you can still turn your collections over. You can still file a lawsuit to perfect the judgment. However, you cannot realize on the judgment, meaning you cannot garnish, you cannot levy, you cannot do any of those tools that you have to require an owner to pay or force an owner to pay. Those will be prohibited until November 1st unless it's extended. And it has automatic authorization to extend these provisions to February 1st of 2021. It has very large disclosures that you are required to send to your owners as debtors, saying, dear owner, due to the COVID-19 pandemic, the association cannot force you to pay. You can ask for a payment plan. You can still voluntarily pay through a voluntary payment plan, but you cannot be required to pay. And it's only a deferral. Late fees, penalties, and interest will still accrue. However, you cannot, like I said, you can't go out and get the money. I think it's going to take a lot of education and a lot of informing your owners what this means, because what it really means is come February, if they have not paid anything, as late fees, penalties, and interest continue to accrue, the balance due come February next year is going to be very large. And it's best to try and get in front of this. So I think what we're going to have to do is educate owners that while this looks really great to them, not to the association, but to them, it's not. And there is real risk to an association and its finances if owners aren't compelled to pay. But like I said, I fully expect this bill to be authorized today or to move forward. So it's going to be a matter of trying to reach out to your senators, try to reach out to your representatives, and quite frankly, Governor Polis, to see if we can convince them to veto this bill. Okay. Some of the minor bills. And when I say it's a minor bill, this went through earlier. It's SB 20-126, and this is the InHome Day Care bill. I do expect this to pass. It has bipartisan support. It was cruising right along to passage before the pandemic shut the legislature down. It has no fiscal note. It's free to the association to enforce, or free to the state. So it just prohibits the enforcement of any covenant that would restrict a duly licensed daycare facility in the community. So again, it's one of those things where you can't restrict an owner from operating a licensed daycare facility. Sorry. Here, let me do, okay. Moving on. So The relevant, and I'll go through real quick and answer some of the questions for that may appear. So if you have questions on any of the statutes, let me know, or any of the bills, let me know. Go ahead and type those in with the question mark. I'll address those now. And the question is, in-home daycare, is this allowed in an age-restricted 55 and over community? Since this is a Colorado-specific bill, we'll have to, quite frankly, find that out. But yes, I think, or no, it would not apply to an age-restricted community because there are not supposed to be any kids living in that community anyway. And the whole point of this bill is local daycare. That during the testimony, the testimony was you had to drive to find a daycare, and because of the limited availability of daycare, you have to get on waiting lists, and this will encourage competition, and this will allow people to walk to their daycare and allow them to have local daycares within the neighborhood. In an age-restricted community, you're not allowed to have any kids living there anyway. So one, it would be, quite frankly, a bad business model if you put a daycare facility in an age-restricted community where nobody's allowed to live. And secondly, the HOPA restrictions allow you, which is the Housing for Older Persons Act restriction, allow you to discriminate based on familial status to some extent. And no, I don't think it would be applicable. So with that being said, any other questions on the legislature? And like I said, because of the way this was cut short, I really don't have, there wasn't much legislation to talk about this year. And because of the COVID-19 pandemic, there's not a whole lot of cases either. All right, Bernie Scharf. Hey, Bernie, do you think licensing of property managers will ever come back? There is a lot of property managers that lack proper education and training for the responsibilities they've been given. And in answer to your question, no. There is some dispute or disagreement amongst the legislative body and the Attorney General. The Attorney General has given an opinion that in order to regulate an unregulated industry, you have to do a sunrise report, meaning you have to go study the industry, study the issue before you can introduce any legislation. The legislative body believes that since manager licensing was previously regulated, they can bring it back without a sunrise report. Nobody wants to have that fight, so I don't think it's ever coming back. But the bottom line is, right now, nobody's got the desire to do a sunrise report on manager licensing, given that Governor Polis has already vetoed it once, has deemed it by veto. It does not need to be regulated. There are better ways to regulate it. So no, in answer to your question, I don't think manager licensing is ever coming back. It is going to be dead forever. And the further removed we get from when it's sunset, the more likely it is going to be required to have a sunrise report. And given that, I think there's just no desire to go down that path again. It is PowerPoint on the website, and email education@altitude.law and we'll send you the PowerPoint. Thank you for that question. All right, moving on to the cases. Again, a relatively slow year for cases coming out of the HOA world that were broad enough to have a discussion. One case related to easements. What does it take to create a valid easement pursuant to the Colorado Common Interest Ownership Act? There was a hail claims case that has major impacts, and we're going to talk about that for just a minute. And then creation of communities, valid and not so valid ways to create a common interest community, and what the implications of doing it certain ways are. So, first case, Croson v. Shenandoah HOA. This came out of La Plata County, and for those of you geographically challenged, kind of like me, that's Durango. So, what happened in that case is there were vague references to an access easement, or vague references, the court determined that vague references to an access easement was in fact sufficient to impose an easement upon the burdened association. Okay, and of course, what does that mean? Well, what it really means is a developer came in. The second part of that story the second part of this case also related to the actions of an individual director. And this is where you as managers and you as directors really need to be careful with what you're saying and what you're doing. So the second half of this case was the board member statements denying existence of an easement were sufficient to support a claim against the board member individually for interference with contract concerning a failed real estate transaction. So what happened in this case? Which, again, the devil is always in the details. Sorry, let's go back to that. All right, so the developer owned a large chunk of property and was creating a community of large lots. And when they were creating the community, what they did is they created Shenandoah and built it out and sold lots. And in the plat referenced a blanket easement across the roadways. Actually, it was a blanket easement across a certain tract to serve the adjacent neighborhood. That's all it was. That's all it said. And then when the developer stopped developing Shenandoah 1, went to Shenandoah 2. And actually, it wasn't really Shenandoah 1 because at the time the developer didn't know it was going to be a Shenandoah 2. So they created Shenandoah 2, and relying on that easement, started to develop the adjacent neighborhood. So a board member, of course, and I'm sure all of you have experienced this, a board member came and said, why are people driving through our streets, our private roads, our private streets? Why do they get to drive through our community to get to their community? And when an owner went to sell their house in Shenandoah 2, of course, the buyer doing their due diligence, wanted to make sure there was proper access, got hold of the board member, and the board member said, no, absolutely not. There is no access. There is no easement. You have no access to that property. Go away. Well, of course, the owners of the property to be sold sued, saying we do have a valid easement and you cost us money because our contract canceled solely because of your statements. And what the Court of Appeals, what the trial court said, and was upheld by the Court of Appeals, was that these vague references to an easement for ingress and egress to adjoining neighborhoods or to the adjoining neighborhood was sufficient to identify both the burdened property, being the Shenandoah subdivision, because it appeared in their plat, and then also because the board member spoke out of turn, and because the board member went with certainty, said, no, there is no easement, those statements were sufficient in nature to hold him responsible for the damages of the owner trying to sell their house. Now, what the court did there is, and this is, again, we take some solace in it, where the owners sued for not only their damages being their carrying costs of the property due to the lost sale. They could have sold it, say, November 1st of any given year, and if they held on to it for 5 more years, the court felt that what their damages was the carrying costs of carrying that property for X number of years. It was from, it related to taxes, and it related to maintenance, and it related to mortgage debt service if you had one, and it related to all sorts of other things. But the owner of that property was not entitled to lost profits. And the court's reasoning was that since the owners would eventually be able to sell the property, there were no lost profits. If they were made whole for their carrying costs, because they still had that asset, they'd eventually be able to sell it, there would be no lost profits. So the court denied that claim for those, which, again, is some solace. But the moral of that story is really, when you have a board member that wants to go out and start communicating statements of fact to neighbors or statements of fact to the existence of a certain property right, you need to make them stop, or you need to advise them that they need to let the attorneys do the talking, and they need to let the proper people do the talking so we can shield the board members from any potential liability. We don't want them going rogue and going off script. We want to make sure that the board members absolutely stick to what we talk about. Okay. And okay. Moving on. Now, like I said, this one is a local case that was in federal court, and it's Sunflower Condominium Association v. Owners Insurance. And this was, unfortunately, a bad fact pattern, which resulted in very bad results for the association. And it's kind of a culmination of a lot of different things. It involves a hailstorm that impacted the community. And as we kind of walk through the timeline, it's you kind of see how the insurance company looked at this and how the court kind of looked at this. But it started with a hailstorm that occurred on September 29th, 2014, which wasn't reported. And nobody told the manager. And the association didn't make any indications that they had been severely damaged by that hailstorm. So about 6 months later, 5-6 months later, the manager hired a roofing company to come out and repair a leak on the roof. And the roofer noted that, hey, you have a lot of hail impact. You got some hail damage on these roofs. You probably have a claim. You should start investigating it. Well, then fast forward to September of that year. So, again, another 5-6 months go by, a full year after the insurance or the hailstorm occurred. The association notified or retained a public adjuster and notified its insurance of the potential claim. Another month after that, in late October, they presented the statement of claim or the statement of loss to the association's board of directors. The association signed it, sent it off, and in December, the association, December of that year, so almost, what are we talking, year, 15 months after the actual hailstorm, they start working on a scope, they obtain a scope of work resulting from the storm, and they agree to a scope of work for about $857,000 worth of damage. Well, their statement of loss they got from the public adjuster was considerably more. So the association instituted a lawsuit against the insurance company in bad faith. The insurance company countered with a belief that the claims were barred in whole or in fact as a result of the association's misrepresentations, false statements, and non-cooperation with the association's insurance company. Very big statements. And it had to do with, like I said, there was this very large delay in reporting time, a year and a half. And the fact that nobody noticed that there was insurance or there was a hailstorm and a hail claim, and that it could have been caused by a hail claim in 2009. So when the association just submitted their statement of loss, there were a lot of questions. And what happened was that the bottom line is the association's insurance company was effective in convincing the court and the jury that the association delayed reporting, which prejudiced the management or prejudiced the insurance company, and the delayed reporting was false. Their statement of loss was absolute false and should not have been submitted at all. And that, given that, the remedy that they sought was complete and total divulging of the association of the insurance proceeds they had already received based on the approved scope of loss. So and this also, because, as I mentioned, the board of directors just signed the statement of loss that was sent to them. The association tried to show that any fraud or any misstatements were not the board's misstatements, but were rather the public adjuster's misstatements. And the court imputed that fraudulent intent and fraudulent statement to the board because they're the ones that signed the statement of loss. So with that imputed fraud that went to the association, all those insurance proceeds were required to be returned to the insurance company. It's like I said, this is a very bad set of facts and a very bad result for the association. But it's out there. The moral of this story is going with, first, make sure that your boards know what they're signing. 2, make sure that you are fully apprising your insurance company of damage when you notice it. When you first notice it, make sure you're getting on that. You can't leave these hailstorms and the damage from the hailstorms just to sit and linger. You really need to go out. You need to make sure that you are addressing these, and you really need to make sure that you stay on top of these and process these claims, because the insurance company, as they continue to increase your deductible, they don't want to pay for hail damage to the roofs. They're trying to make you self-insure, and they are going to go out there and they are going to vigorously defend these potential claims, and they will absolutely pick apart your claim if they possibly can to reduce coverage. Public adjusters have a place and a job to do, and that's great, but they need to make sure that what they're giving is real. They need to make sure that what they are saying is appropriate. And also, as we had talked before, management company fees to process claims are not part of the claim, and they cannot be included in part of the claim. And your public adjuster fees that you pay to a public adjuster are not part of the claim, and they cannot be included in part of the claim. So don't be tempted to increase the amount of the claim to cover some of these costs that the association may or may not incur. You just need to make sure that you acknowledge that they exist. They're not illegal. The management companies can charge these fees. Just make sure that they are fully disclosed. Just make sure you recognize they are not part of the claim, and don't try and slip them in part of the claim. Again, they don't belong there. It's a question of, so what was the impact to the board, personal liability? How do roofs get repaired? Well, the roofs got repaired. They're going to have, that association would have to special assess. If they had to return those monies back to the insurance company, it would have been a special assessment to the owners. And the case did not indicate whether it was going to be personal liability of the board members. So I think that is something that's a very good question, and you've got to make sure that, remember again, your board acting through the business judgment rule is not a guarantor, and they are allowed to rely on the advice of their professionals. It was the imputed fraud that got there. So I think each individual board member would still say, I did not act fraudulently. It was just imputed to us. So there would be no board member liability. But that's a really good question, and we need to make sure that, again, when you're processing these claims, your boards are fully aware of exactly what they're signing, what it's comprised of, and don't make them ask questions. And when I say make them ask questions, make sure you as managers fully tell them what's going on and what's being signed, and bring in your public adjuster to explain exactly where they got their numbers and where they came from. That way the board can be insulated from that potential situation as the association, because then the association can say, no, stop. This happened, and these went in there, and these this happened, and it protects them. And we want to make sure the board is fully involved in these, because again, this was just a very bad set of facts, and I want to make sure that claims are not. This is obviously the exception, and I want to make sure that again, but we don't want it to reoccur. Okay. Okay, we talked there, and again, the association's failure to promptly report exaggerated its claim. Notice the insurer was delayed. The proof of loss had misrepresentations, and the liability was vicariously attributed to the board. And again, it's just something I cannot stress enough. We move forward with that. Okay. The other one is FD Interest, LLC v. Fairways at Buffalo Run, Homeowners Association. And this is what not to do. This is kind of more of what the developer should and shouldn't do. And if you recall the recent cases that came down, they were the sister cases of Countryside Homes v. Pulte and the Ryan Ranch decisions. And these were twin decisions that essentially instructed builders how to develop a community. And in the Pulte case, Pulte had an option to buy a number of lots, was actually buying lots, not buying dirt, but buying lots. And they brought them into the community as they developed them. So the association saying, hey, all these lots appear on the plat, and Pulte, you're using association funds to maintain some of the stuff, so you owe us assessments on every one of your lots. And the Colorado Supreme Court said no. there's a way to develop property, and there was no property subject to the declaration when it was originally recorded. And then as they built a home, they brought it in one by one or block by block. And assessments became due and payable when those properties became subject to the declaration. And then in Ryan Ranch, went and said, okay, when you develop a community, not only do you have to bring those supplements in, but also you have to have a deed to convey the common elements. And you have to have some indication that this property is intended to be part of the association. Well, in FD Interest v. LLC v. Fairways of Buffalo Run, this was a developer who was playing a shell game, and I say that he had one entity be the property owner, and another entity be the builder of the homes, and another entity actually sold the homes to try and kind of keep it all in-house, but they were all the same person. And when they recorded the declaration, it said the entire community was subject to the declaration. Even though there were no houses, even though there were no property, it said there was originally planned to be constructed, I think 64 homes. And in those 64 homes, none of them were built when they recorded the declaration. Because of the economic downturn, only about 12 homes were built. So the association sued, the developer sued the association for access to common areas, which had been denied. And it blew up into a much larger lawsuit into what was required. Even though the developer, and again, you have a bad developer, you have a bad acting developer who the property was owned by one party, but signed it under the name of another party. And was that sufficient to bind the property? And the court felt that yes, that was in fact sufficient to bind the property. And as a result, all of the property was subject to the declaration. Now, when those development rights expired, pursuant to the terms of the declaration, the association can reinstate them pursuant to whatever terms and conditions the association determines appropriate. So what you have is a situation where, because the entirety of the property is subject to the declaration, the developer can't develop it without the approval and consent of the association. And the court felt that that was in fact sufficient to bind that property. Now, I will let you know, the Colorado Supreme Court has officially accepted cert on this case. So this one isn't done yet. We have to find out, again, the Supreme Court's going to look at this, and my hunch is they're going to come down and try and find, now that they had two good developers in the Pulte Homes case and the Ryan Ranch case, what do you do with a bad developer that did none of the things that they were required to do? Do you let a bad developer get off? And how do they react to this? And I think that's going to be where that case goes, and how the Supreme Court looks at it. But again, that's cert was just accepted. None of the briefing is done. So we'll have to find out exactly how that moves forward. So we'll be talking about this one again next year. Okay. And now the bonus case you get is Cool Space LLC versus Boca View Condominium Association, Inc. And the general statement in this case is the court used strict interpretation of the documents in limiting the association's authority. Now, what this case started with was an owner came in and bought a unit and decided to rent it because, hey, it's in Boca Raton. It's going to be a great rental, probably a great short-term rental. Conveyed the property by quitclaim deed to Cool Space LLC, upon which this individual owner was the sole member of this LLC. So the declaration said that in order to preserve the property values of the community and the financial investment of its owners and the quality of people living in the community, no unit shall be leased without the approval of the board of directors. Well, the board took that as, well, we have the right to review tenants and leases, and we have the right to protect the type of people living in the community. So they said, owner, we don't recognize your conveyance to your LLC. You cannot convey it. You have to reconvey it to yourself, and then you can come back and ask us if we'll let you lease. Well, the owner sued and said, first, your documents don't allow you to say when a unit can be conveyed, that it allows you to do the leasing piece, but it does not allow you to say who can own a unit. And ultimately, the association lost because the court used the strict interpretation saying, yeah, it says you can protect the property values, and yes, you can look at who's living in the community, and we'll, in about 2 seconds, talk about the problems with that. But you don't have the right to say who can or cannot own a unit, and told the association not to do it. Now, I have bigger concerns upon just the association approving the leases. What that association was doing is they were saying who was allowed to live in the community. And they were trying to find people that were just like them to live in the community. And I think that is wrought with peril. If you have a board that wants to try and say, owner A, you can live in the community because we have the right to approve approve conveyances, or B, we have the right to approve who lives in a unit through a tenant, and we're only going to let certain people live in the community, that reeks of discrimination pursuant to the FHA. And even if they have no intent on ever discriminating, and even if they have no intent on trying to pass judgment on certain owners' race, creed, religious background, sexual identity, the fact that they have that authority to becomes very, very problematic. And that is something that if it happens to appear in any of your governing documents, I'd amend you adopt a statement saying, we don't enforce it, we don't do it, we want it removed, go to your owners, have it try and removed. There is no provision that'll get you into trouble faster than that provision, or trying to enforce that particular provision. And why the court didn't address those issues, I'm not sure, other than the fact that they probably just weren't asked to adopt those particular provisions. So we have a little bit of time for questions if you have any, and please fire away. Okay. Well, it has been an absolute pleasure talking to you today. I thank everybody for attending, and I will keep this link open for 5-6 more minutes in case anybody does have a question. There we go. Yay, questions. Okay. Wait, where'd they go? Thank you, everybody. Have fun. Regarding the daycare, her HOAs have to allow fencing. Okay, thanks, Christine. Okay, regarding the daycare, I heard the HOAs have to allow for fencing for the daycare. They do. It's any restriction that prohibits the operation of a duly licensed daycare is prohibited. So if you have a licensed daycare setting up, they have fencing requirements. So you're going to have to allow for the fencing in accordance with the state requirements to that. So again, a very good question. It's not just allowing the operation of the daycare, but everything that's required to allow the daycare to operate must be waived. So if you have a community with a no fencing restriction, that no fencing restriction is no longer valid as to that daycare. Then you can also require that fencing be removed if the daycare ever ceases to operate, but you have to allow it. And another question, on religious symbols, can the HOA limit this to the rear of the property? No, you cannot limit it to anywhere. The case that brought this to light is a mezuzah, and a mezuzah is a small prayer vessel for somebody of the Jewish faith, and they're required to put it on their door jamb as you enter the home. And an association tried to have them remove that from the common elements, because in a condominium, the door jamb is a common element, and this statute will absolutely prohibit that ability to remove it. So you can't restrict it to the back. It has to be allowed on the front, it has to be allowed on the door jamb. You can restrict it to a 6x6, but if somebody wants to put a pentagram because they are a Satan worshiper, there's nothing you can do about it, a sincere Satan worshiper. If somebody wants to put, like I said, a cross, a crucifix, you name it, they are allowed to put it on the common elements. All right. Thank you so much for that question. That was awesome. All right. Well, thank you so much. And like I said, I'll stay open for a little bit longer if you want. Just let me know.